Hi. A lot of people ask, what do I do about my mortgage and my car loans? Mortgages and car loans usually contain clauses that allow the lender to take something, like the house or the car, if you don't pay for it. These type of loans are known as quote-unquote secured loans because it's secured by the property. The payment is secured by the property. If you are behind on your payments on a secured loan, the lender can ask the court to grant relief from the automatic stay in bankruptcy so that it can foreclose or repossess the property. You cannot stop the creditor from doing this, whether or not you file bankruptcy. However, if the amount that you owe is greater than the amount the creditor sells the property for, which is often true, you must pay the difference in that in how much they get if you don't declare bankruptcy. But after you've declared bankruptcy, that difference between what they obtained for the property by selling it and what you owe them is erased, and you won't owe anything after the property is taken back and sold at auction. Now, you have several choices to make with respect to secured property after you file bankruptcy. The first choice is that you can simply surrender the collateral being the car or the house underlying the loan that they can take back. If you give the car or the house back to the bank, you're going to owe nothing because after that, the bankruptcy filing wipes out the underlying debt. That will give you a completely fresh start, which is actually the purpose of bankruptcy. The second choice is that you can redeem the collateral. If you owe considerably more than a piece of personal property is worth, you can pay the creditor a lump sum equal to the market value of the property. And if you and the creditor disagree on the market value of the property, a valuation hearing will occur and the judge decides what the property is worth. This is only good for personal property because business property cannot be redeemed. Now, to be represented at the extra hearing, you'll have to pay an additional attorney's fee, and in most cases, people don't have the cash to do this. The third option is to retain the property and pay for it in the same way that you paid for before. This simply involves keeping the property and keeping the payments current. Most creditors, but not all, will accept this. There's a few isolated creditors who refuse to accept this. One of them is Ford Motor Credit Company. That company will try to repossess cars as a matter of policy, even if it incurs a financial loss in order to do it. Others will often demand a reaffirmation agreement and go so far as to threaten to repossess. But even though they may warn and threaten, most won't do anything in the long run, as long as you make your payments on time. That's because even though you think they want to repossess your car, they don't. Every time they have to do a repossession, it costs them money. They have to hire a tow truck, they have to pay commissions, salaries. For everyone involved in that repossession, the creditor will only be able to sell it for greatly depreciated value, as opposed to getting back the full value as you pay off the loan. And the bottom line is, there's some risk in playing a game of chicken with car loan creditors, but usually, not always, but usually, all you need to do is keep the creditor payments current, and they'll let you keep the car, even though they will complain that they won't or threaten that they won't. We recommend this course of action if you need to keep the car and if you can't pay it off. The fourth option is to reaffirm the debt. A reaffirmation agreement is a new promise to pay. If you sign one, you'll be legally allowed to keep the property that binds both you and the creditor as if you've never filed bankruptcy. That's what Ford Motor Credit Company wants. But if you stop the payments and if you get behind again, they can repossess it and they can hit you with the same deficiency judgment for the difference between what they get for it and what you owe that they would have if you never declared bankruptcy. For example, if your car is worth $10,000, you owe $22,000, they'll hit you for $12,000. That's even though you've declared bankruptcy. You don't get out of the debt because you reaffirmed it. You signed a new agreement to pay it. And then they will garnish your wages or take whatever property they need in order to collect it. That's why I recommend very strongly that you do not sign any reaffirmation agreements, even if you will lose the car, because the reaffirmation defeats the basic purpose of filing your bankruptcy. Now, the fifth option is that you can surrender the collateral, and this is often the best alternative. Just give it back to the lender and have done with it. You can usually go back and buy a similar vehicle, for example, often cheaper with lower payments. And so while you're thinking about about that right now, I would suggest that you go and investigate that possibility. Look for a used car, even though you will pay probably a high interest rate given that your credit is not too good by now. It's often a better decision than trying somehow to keep the one you now have. So, hopefully that's given you information as to what to do with your cars and other secured property. I hope that you put a like at the bottom because it really helps us get these videos out to more people. More people will see them. The Google algorithm will send them out to people more often. So, if you like this video, hit the like button. Thanks.